So one of the key groups that this amendment addresses that we have to always keep in mind and care for is the innocent bystander. To use a legal phrase, but for drivers, injuries would not be caused to innocent children on the sidewalk, to the kid getting a ride in the backseat of a car to a baseball practice, to a senior citizen walking to a park. And when an innocent bystander is injured, they are put into something called the assigned claims pool. And this is where all the drivers who are taking and putting themselves at risk and other innocents at risk pay into through the insurance companies to make sure those individuals are cared for. Because we passed this legislation in the way that we did, in a way that a 120, 130-page bill was written so quickly that it's just plain sloppy. Because we did that, because we didn't take care of the effective dates, and because we broke the House rules and gavelled effect without having the number of quorums stand, what happens is that this sloppy legislation now takes from those innocents their health coverage for the injuries that have been caused to them by drivers who chose to drive through no choice of their own. And because it was so sloppy and the effective date is wrong, it will cap that benefit for them at $250,000. Whether or not you have injured a child for their lifetime, you've paralyzed them, you have put someone in a coma, or given them a traumatic brain injury. Because we were sloppy about the way this was done, that has been capped immediately, upon immediate effect. It also means that as drivers, the current rates that we're paying, the insurance companies that we pay them to, now no longer have to cover these injuries. And so someone's making an extra dime. I ask that my colleagues support this amendment to do what we meant to do, which was to have this go in effect when all the other changes went into effect. Thank you.
Questions on the adoption of the amendment? Clerk will open the board. The amendment is not adopted.